Thanks for coming. Welcome to the Senior Empowerment True Series. This is our June seminar, sponsored by Parson Realty Group and Mature Move Solutions. I'm Stephanie Parson, so I'll be your moderator, I guess. Our topic today is the truth about trusts and wills. And before we get started, a couple housekeeping tidbits. So I'm going to be asking a series of questions to our two panelists today. It runs till about 11 or 11:15. At that time, we open it up to audience questions. You have a handout at your table, and so that's to jot notes down so that when we open it up for questions, feel free to raise your hand and you can ask a question then. The yellow or goldenrod sheet is feedback, comment, information that we read every one that we get. So we'd love for you to give us feedback, good, bad, give us ideas about other topics. And then real quick, we have a no selling policy. So we're not going to try to sell you anything today or any particular service or product. We're providing education. So panelists today will discuss industry norms and general information and pricing. And if you have very specific questions for them, they're going to hang around afterwards. They will also have information at the back table that if you would like to pick it up, feel free, okay? We'll have a box in the back for your evaluation. Maybe it'll make it a little bit easier and less confusing for everybody on what to do with them. So without further ado, let's get started. So just curious, how many of you have a will? Yay, quite a few people, okay. How many of you have an estate plan? Not so many. Okay, all right. So it's interesting that we all want to control our day-to-day lives, but so many of us rarely think about, what happens after we pass. And we fail to leave our family, our heirs, proper instructions or directions on our wishes in dealing with our affairs or our estate. So let's learn today from our expert panelists on how to keep that control and properly plan. So welcome, guys. You want to share your names and who you're with and why you do what you do.
So I'm Raymond Chandler. I'm with the Polaris Estate Planning and Elder Law Group. That's what we do, estate planning and elder law. We want to make sure people have their estates in order and their instructions left behind, mainly because my family got torn apart from it, and that's why I'm here. That's why I do what I do, because I've seen it firsthand, where we don't talk to certain people in the family anymore because the farm didn't go where it was supposed to go, and things like that. We also don't talk to somebody else because of the Betty Crocker cookbook. So it can be big, it can be little, but what we want to make sure is the families know what to do and there's no fights, and that we make it as easy as possible for everybody.
Okay, great, thanks. Thank you for being here.
So my name is Stephen Jones. I am the founder of Jones Elder Law. That's me right there in the middle. Strikingly handsome, I know. So we also focus exclusively in estate planning and elder law. We don't do anything else. As part of that practice, we are advising families on, what fits with their needs, what fits with their goals. I came to this practice after leaving Bryan Cave, which is one of the big firms downtown, because I realized a couple things. One is that I want to work with my clients, okay? And in the big firms, we weren't getting that interaction. The joy I get out of this practice is sitting with families and being able to help them go through this process. The reason I feel this way is because my grandmother spent 9.5 years in a nursing home. She had Alzheimer's for close to 15 years. I know exactly what happens if you don't know what to do, okay? So our clients are coming out of our planning sessions with a plan and with an idea of exactly how they're going to do things. And then what we do is, you can always come and ask us a question. You can always come back and talk to us. We don't bill you for that. We're not the big firms that bill you in every 6-minute increments. So that's the way we've chosen to set things up so that we do help guide our families through the process.
Okay, so you both are attorneys that specialize in elder law and estate planning, correct? Okay.
Correct.
You were talking about billing and how you're different from a big firm, right? Any,
Same thing, we do everything flat fee, so that's one thing, if you're looking for estate planners, number one rule is, if you use one of us, great, if you get your estate plan done, that's what the goal is. But one of those things looking for is flat fees, so you don't get hourly rates, because there's a lot of questions that come up here, a lot of information that needs to be provided, and if you're clicking that clock every time you call, every time you have a question, it's not gonna be good for you or your family, so we do the same thing where it's flat rates, depending on what we're doing.
okay, great.
A lot of estate planning attorneys will do that.
Okay, awesome, because I know attorneys I've dealt with before, it's by the hour,
Yeah.
so it does rack up quick. Okay, so talk to us, a lot of people raise their hand that they have wills, but not so many about an estate plan. So, can you talk to us about what the process looks like to do an estate plan? Ray, would you like to start us off?
Yeah, so the first step in creating your estate plan with an attorney, and I'll go my experience dealing with that. Sit down and discover what your goals are. So really sit down and ask you about your family, about your issues, about your goals, about your wishes, about what you want to accomplish, about who you want to be in charge at certain times, and take that time to sit down and counsel you through that process. And a lot of that should be asking questions for you that you would ask if you knew what we knew. Because we know the questions to ask, but sometimes you don't. So we want to ask those questions for you, with you, and really figure out what that plan is going to be. And then decide how we're going to build that plan, how your estate plan is going to be built, whether it's trust-based or not, whether it's what type of trust-based it is, something of that nature. And then build that plan and put it together. And then once you've got that plan together, now we have to take your plan and apply it to your property. So then we have to make sure that your property is funded into your plan properly, that all of your stuff ties to your plan properly. And then a lot of times we'll continue the process even beyond that and maintain your plan and make sure that you're always looking at your plan at the proper times to make sure it keeps up to date with you, the life, law, your assets, your property, and everything of that nature.
Steve, anything to add or elaborate on that?
I think our process is similar. I mean, we do pretty much a very similar practice. We refer to our first meeting as a vision meeting. It's really a guided conversation. The most important question I ask people, and I was talking to someone earlier, is what are your goals? And one of the things that we see routinely is when people come into our office and maybe they have some documents in place, and we start talking about their goals, they realize that they didn't even know, and I think this goes to what Ray was saying, what their goals might need to be. Okay, so a typical estate plan from an estate planning attorney, and I'm not saying this is bad, is probably keyed on probate avoidance and incapacity planning, those two things. But if you sit down and you ask most married couples, if one of the two of you gets sick and need long-term care, do you want to protect the assets for that healthy spouse? Almost every single one, and in fact I've not met one yet that didn't say, yes, I don't want the assets being taken away so that my loved one is living on rice cakes and in the dark, okay? But what you find is because of the attorney that they may have visited with, that question was never addressed. That goal was never discussed, and their documents fall short of doing that. So the process is very important that you internally know what you're trying to achieve, and then hopefully you're meeting with someone who is helping you, if you haven't identified it, to identify those. Because it's like anything else. If you have the wrong plan, it doesn't achieve your goals.
So it sounds like you guys ask a lot of questions because we, as not attorneys or experts, we don't know what we don't know. Is that an accurate
Sure.
statement?
Exactly.
Okay, perfect. So does everyone's estate go through the dreaded term probate? Steve? you wanna start?
It could, but it shouldn't. So if you've done your planning correctly, and this is my view, okay, there are attorneys out there who will tell you probate's fine, go through probate. I think it's because they get paid. But if you plan it correctly, you should be able to avoid probate. What most people don't understand is that probate is really about the transfer of assets and making sure that creditors and heirs are getting what they're entitled to. So one of the first things you have to do in probate is put out the sign, they call them tombstones, in the paper and say, hey, if you think this person owed you anything, give us a call. Come and get your money, okay? And so that process doesn't serve anyone's interest usually that's an heir. It serves interests that are external to the family. So in our world, we're trying to avoid that, okay? The way you do that is with your estate plan. So if you have things in your trust, if you have things with a beneficiary designation, a pay on death, a transfer on death, even the dreaded put your kid's name on the account, those will avoid probate. But that account that has just your name on it, and you pass away, that's going to probate, okay? And that's when you're going to potentially spend a lot of time and money in court.
Okay. So Ray, do you have to hire an attorney to go through the probate court?
To go through the probate process, you do, because you have to have an attorney in Missouri, and you should, because it is confusing, time-consuming. There's a lot of things that need to be filed, and notices that need to be filed, and things that need to be done, and there's a lot of questions there. So it's one of those things where even if you didn't have to, but you kind of have to, you should, your family should. And again, that's one of the reasons you want to avoid probate, because one of the costs of probate is the attorney fees. And the statutory minimum is there that says this is the minimum reasonable fee. And like attorneys, not all attorneys are good at arguing everything, but every attorney is arguing that their higher fee is more reasonable. So you gotta watch out, because they will go higher than that. So trying to avoid probate because of those type of things is why that's one of the goals, is to avoid the need of the attorney at that point in time on the probate side.
Okay, so yes, you do have to hire an attorney.
Yes.
It's not a DIY, you can Google it and all of that.
Yeah.
Right.
The court's not going to let you come in
Yeah.
and say, hey, can you help me get through this?
Okay.
They're going to tell you to go get an attorney.
Yeah.
Okay, all right, okay. So, is probate just for real estate?
No, probate is for anything you own personally in your name when you pass away. So it's for your house, it's for your investment accounts, it's for your $500 car. We've done probates for those before. If it's not set up and in your estate plan properly, it'll go through the probate court to get where it needs to go.
So what challenges do you most often see in the probate process?
I think for us, it's an informational issue. So a lot of times when people come into our office and they're kind of encountering probate, they don't have a very strong understanding about the decedent's assets and what they had and how they owned them and that type of thing. And that is the first step before you know what or if you have to go through probate. The problem is if they didn't do an estate plan, they probably also didn't bother to tell their kids and or family members what they had or anything. They're probably somewhat, keeping that to themselves. And so now you go through this process, and the first thing that the attorney is going to ask you is, okay, I need to know all about all their accounts. Well, I don't know about their accounts. Well, you have to start getting that information. And you're going to go and you're going to call, a bank, or you're going to call somebody. Well, they're not going to want to talk to you too much because you don't necessarily have authority. The power of attorney now is not any good because you passed away. And so those types of things create problems. And so you spend a lot of time and effort going through that information gathering. We had one client in our practice that they started out thinking their father had maybe $100,000, $150,000 in assets. And somewhere along the way, they found this big tub like you get at Walmart. And I mean, it was full of paper. That was his filing system. He got a letter and he put it in the tub, okay? And it was full of insurance documents. And they had to start calling insurance companies to find out if they were valid. And you would not believe, the insurance company changed from this company to this company, and then they went over to this company, and they have to call every one of them to try to find their way through, only to find out, oh no, he let that lapse. But they did end up finding more assets, and that process was very time consuming and very frustrating for the family. So to me, it's that lack of information, that inability to gather just even the most basic of things to kind of get the process undertaken.
Okay, thank you. So, Ray, is there, what's the best way to avoid what you both just talked about, this research process?
The best way to avoid all this is to have a proper estate plan. And That's the easiest way to answer that, is have a plan in place for you and your family that you know what you own, having a report of everything that you own, and having an estate plan that shows where it's supposed to go and who's supposed to be in charge, what your instructions are, and things of that nature. So the best way to avoid that probate, or what we call a morbid scavenger hunt, running around trying to find everything when someone's dead, is to have that plan in place ahead of time.
Okay, perfect. So let's talk some numbers. What can someone expect to have to pay in probate? And what is probate based upon?
So the probate fees are based upon the assets that pass through the probate estate. So in our practice, when we're meeting with a client, we'll kind of start out at the very basic first meeting, and we'll draw 3 columns. And we'll say, okay, here's your trust, here's your individual name, and here's your assets that will pass because they have a pay on death, beneficiary designation, transfer on death, or something else. And so then we start kind of scheduling out where things are. That middle column, where it's just in your name, that's probably going to probate, okay? And so if you added all those up, that would be what would be subject to probate. Then as we've already kind of alluded to, Missouri very graciously has a minimum fee. That is a minimum fee for the attorney and the personal representative, okay? And you can expect that combined, that will be probably in that 4 to 6% range of your assets. So just rough math, if I have a $200,000 home that goes through probate, I can very easily see a $10,000 probate fee. That doesn't count publication fees, that doesn't count court costs, or anything else that's kind of extra. So that's one of the reasons that I would tell you probate's not good for you, okay? Our practice model, we don't do tons and tons of probate because our clients are being planned to not go to probate. Most of our probate cases come from a client of ours who says, oh, my sister had this happen, or my neighbor had this happen, and we end up helping those folks, but not by design. We never intended that any of our clients would go through it.
So you get those clients by default because they failed to plan.
Because they didn't plan.
Yeah. So you use an example of just a home. So which most of us have more than just a home, fortunately. So I just put some numbers together. If you have a house that's say $400,000, $20,000 in your bank, your car's worth $20,000, $60,000 in retirement, you have an insurance plan of $100,000, so a total of $600,000, and we use 3 to 5%, so that's $18,000 to $30,000 to go to pay for probate plus all the other fees.
Yep.
So who'd like to avoid this much money going to probate? I know I would, yeah. So now we have a true or false. True or false? Probate process is expensive, time-consuming, and should be generally avoided if possible.
True.
True. Yes. All right. Awesome. Going to talk a little bit about power of attorneys now. So, true or false? All I need to sell a deceased family member's home is a power of attorney. False. So, guys, I have someone come to me as a realtor that has a power of attorney, and their parents have passed away, and they say, we need to sell mom and dad's house. Is there a problem with that?
Yes, because the power of attorney is no longer valid.
Why?
Power of attorney dies with you. So your power of attorney puts somebody in your shoes, and you're not there anymore, they can't be there anymore either. So that's one of the big problems with the power of attorney, is that it stops at your death as well. So it's not going to help your family when you're gone.
Okay, all right. Pretty short, concise answer.
There's really not much to answer.
It doesn't work.
I would just repeat the same thing.
The reason that's in there is
Yeah.
because in my line of work, I get a lot of people who say,
Yeah.
oh yeah, I have power of attorney. Well, one, there's different forms of power of attorney,
Yeah.
and two, like you said, it's no longer valid, so it doesn't work. We have to start elsewhere, which
Yeah.
if they don't have a state, it's.
Yeah.
we're
There's a lot of
waiting for
confusion
probate.
on power of attorney. One of the big things for you to know when you're granting a power of attorney to someone, you are not granting them carte blanche control. They still need to follow your instructions and your wishes, and you can revoke it at any time. So you're not like, we get it, well, if I get power of attorney, then they can force me to do stuff. No, they can't force you to do anything. They're supposed to follow your wishes. The other thing is not every power of attorney is the same. And we see it all the time where there's a lot of powers of attorney out there that don't actually have the powers you need. They just have quick, you can get into the bank account, great, but you can't do anything else. Well, then the family runs into the wrong, they can't do what they need to do while you're alive taking care of you. And so not all of them are created the same either. So you have to have a very specific power of attorney to meet your goals.
So there's a lot of information on the internet. And there's forms that you can get on the internet. So are those things that are all valid? Is that something that if we're trying to be really cost effective, use forms like that?
Well, obviously you can try to use whatever you want.
Yeah.
I would tell you that if you have accumulated assets, that would be one of the most penny-wise, pound-foolish strategies you could develop. We see people do it, and they create invalid documents. They create documents they don't understand what they're even doing with them. More than likely, you're making a mess rather than an estate plan in those cases. So from that standpoint, do they exist? Yeah, they absolutely exist. Is it what I would recommend? If I had an individual come into my office with minimal assets and very small families, so limited people to choose from, and they were only going to be able to do that, and they really said, I just can't afford an attorney, then I might possibly tell them that would be a way to look. But even then, I would hate to do it because so many times they can't do it correctly. And I'm not saying that because I'm saying I'm so smart. I'm saying it because it's very confusing. The documents themselves, when you see them, people bring them in, and it has stuff all over the place. They put stuff in it that's in the will, and it should have been in the power of attorney, or vice versa. And so you've got basically nonsense a lot of times. So, it's out there, and there are software systems to do it, but more often than not, we'll end up fixing it for you down the road, and you start over.
One of the things, I've got an ad in my office. It's from Ben Franklin in the newspaper that he was selling legal forms. Because he had his little printing machine, he'd print out legal forms for you. It hasn't worked for 200 years. That's why we're still here. It doesn't work now. The worst case scenario I've seen is we had a family come in with the forms they got online, and it was California forms that now their entire family is stuck under California law with their estate plan because that form wasn't the correct form.
Wow.
Yeah.
So depending on what state you're in,
Yep.
you're
Yep.
ruled by whatever those laws are.
I need to have state-specific documents.
Okay.
Yeah.
So if you live in one state and have an estate plan set up and everything, and then you move to another state,
Generally, you get updated.
it needs to get updated.
Time to update.
Okay. I don't think I knew that either, so.
Now, you do run into cases, like we have a lot of snowbird clients, so then you kind of pick your state,
Okay.
so depending on where you want to call home or where you want to do that. So in that case, because you're not really domiciled and need to place permanently, you wouldn't necessarily say, oh, I got to have Florida state documents for this 6 months and Missouri documents for this 6 months. So there are instances where you could be going back and forth between both, and you would pick one state and that would work. But if you lived in California and you moved to Missouri, you do not want to have California documents as your documents in Missouri. Because imagine you've got this will, and it's got all this wonderful California law in it, and you have to go to probate in a Missouri court. How familiar do you think the Missouri attorney and the Missouri judge are with California law? Probably not at all. So what does that do? Remember your costs? Those are going up significantly.
All right, I can see that happening to a lot of people.
Yeah.
You just assume.
Well, and people
You
don't
created
want
this.
to, people they put their estate plan in place, and then they don't touch it for years. We actually had a client come in, and I'm sitting at our big conference room table. We've got mom and dad who are like 89, 90 years old. We've got their 70-year-old children in the room, okay? And I look at their will, and their will still says that if they die, that their children go to the Catholic home. Okay, that's how old that document was. So they hadn't touched it since. That is a bit extreme. You know, you don't see that all the time, but these are things that as your life changes, as your residency changes, you do have to go back and revisit them and figure out if they need to be updated.
Okay. All right, so true or false? The best way to transfer my money safely to my heirs is with a will. False. Okay. So we talked about a power of attorney won't help, and we talked a little bit about wills. Does a will work in selling the home? And does that avoid probate for the home?
So your will is only the instructions to the probate court, and that's all it is. So it only works in the probate division. So you can't take the will to the bank and say, I was supposed to get the bank account. You can't take the will to the recorder's office and say, I was supposed to get the house or anything like that. You have to go through the probate process for that will to be valid. And so that's one of the reasons why relying on a will is not a good estate plan, because it almost forces your family, if you have nothing else, it's going to force your family into the probate process.
Okay, one of the things I don't think came out yet was, how long does the probate process take in Missouri?
So I generally tell somebody expect a year. What you have to understand is it's statutorily driven. Okay, so you file your matter, you open your matter, then you got to file notice to creditors, then you got to leave it open for a specified period of time, and by the time you get through all that, you're probably 7-8 months out anyway. Okay, and then by the time you get everything closed and wrapped up, to the extent you're having trouble with the accountings from the clients and that kind of stuff, you could very easily be a year. If there's any other problems, it could be longer. Okay. Luckily, we haven't seen it, but I've heard of estates going on for multiple years because they're fighting over assets and they're coming in with motions. You want to talk about increasing your costs? Start having everybody come in and fight about it. Okay? Now everybody's got lawyers, all the lawyers are happy, and none of the family is. Okay? That's the worst case scenario, but you can pretty well count on a year.
So how common is it that people pass away and they're not having everything documented, they don't have an estate plan? How often do you guys see that families are, like you talked about, and Steve, you mentioned too, families are literally torn apart because of disagreements over that? How common is that?
Way too common.
Yeah.
Way too common. What we see most of the time, honestly, is it really, in my experience, it doesn't have much to do with the money as it does expectations and hurt feelings and things like that. So without having a plan in place and telling people what's going to happen, what we see a lot of times is, in the end, the statute tells us what to do, but all those fights and all those hurts and all those old feelings come out. You know, I've had clients sit at the table and tell me about who went to whose baseball games and dance recitals more than 40 years ago, and now they want to fight over the house because of that. And they use the property as a scorecard. Not that they need the money, it's just the less they get, the more I win, is kind of the way we see it. So without having those instructions, without the family knowing what your wishes are and knowing what the goals are, and that's part of your estate planning, we see families fall apart quite often.
And I think, okay, I have a good relationship with my siblings, but
My kids would never do that. I hear that about twice a day.
All right. We had talked about something called a pour-over will. Can you speak to that and explain what it is, and is it necessary?
So we do a pour-over will, as I assume probably you all do as
Yeah.
well. A pour-over will is what you do in conjunction with a trust, okay? So when we talk about just having a will, we would generally refer to that as a standalone will. When we have a trust, we have a pour-over will. And yes ma'am. Pour, P-O-U-R.
Oh,
Yeah, like you're pouring over.
Oh.
Okay. And so what I generally explain that is kind of like a backstop, okay? So if you are going through and we've done all the funding in your trust and everything's in your trust, you're not going to use that pour-over will. Because all your assets are going to either pass through the trust, a beneficiary designation, or something else. But let's say that somewhere along the line you got mad at the bank. And you said, I've had it, I'm switching banks, and I'm going over to this bank right here. And in that process, you didn't think about the fact that you have this trust. So all you did was put it in your name. didn't put any beneficiary designations on it, didn't put any pay on death, transfer on death, just your name. You pass away. That asset can't transfer, okay? And so rather than go to full-blown probate, because we don't want to spend a year in court, right? We want to have to do as little as possible. That pour-over will scoop that asset up in conjunction with a small state affidavit and put it in the trust. That's what you're using a pour-over will for. Now, if you're at the right place and you're working with the right people like us, we don't use pour-over wills hardly ever. It's not something that happens in our practice because we spend a lot of time on the funding process, on educating the client about the importance of things being in your trust. Because there is no reason whatsoever to do a trust unless you're going to put stuff in it. Otherwise, it's a very thick bound of paper that you can use as a doorstop.
So you said you don't use them. Do you create them on the?
They exist in the documents.
We're not going to, hopefully we're not going to need that because
Right.
we're going to stay up to date on everything.
Right. It's kind of like some forms of insurance. I buy homeowner's insurance for a fire. I don't plan to have one, okay?
Okay.
I get it because if it happens, I want my home repaired. Well, the pour-over will is the same concept. I do a pour-over will not because I want to have to use it, but because if something does happen, I don't want that client to have to go to probate.
Yeah, but
Win the lottery and die of excitement. We've got to go to probate real quick.
Well, I think the example you gave about the bank,
Yeah.
it is probably a really common one.
Yeah, we see that all the time.
So, sure, okay, all right. You guys do recommend pour-over wills, but not just as the only thing?
Yeah, you wouldn't, I don't recommend a standalone will. That's really just not something that a client who's coming to us is going to benefit from.
Okay, all right. So another,
Good question.
sorry.
Good question.
You'll probably get to this later, but my father-in-law just passed and there was a lot of amendments to his trust or will.
Uh-huh.
Isn't that what you do if you have a change in the bank or change in what you want to leave? Or
Well, not if you have a change in banks
Okay.
necessarily. That's a funding issue.
Okay.
So if you change banks, you would just say, okay, when I move to this bank, I want to title it in the name of my trust. You don't really even have to involve the lawyer necessarily in that. You're welcome to call us and we'll walk you through it. But changing banks doesn't necessarily change your documents. If you decide that I don't like the trustees I originally picked, I want to switch them to these two people, or I don't want to give this child 22% anymore, I want to give them more or less, those would be amendments to your trust. And so a lot of times you'll see a trust and here's the original one, here's Amendment 1, here's Amendment 2, here's Amendment 3. You have to be careful with that because every one of those amendments makes that trust harder to read and harder to administer. So at a certain point, you do what's called amend and restate the trust, which basically says, taking everything that's been done, this is now what our trust says, and you kind of start over. But it keeps the original date for funding purposes.
Okay, thank you.
You're welcome.
Amend and restate. I like that. We need to be doing that in real estate sales because we get a lot of amendments and then you're like, well, this changed that and then that moved this and you have to really.
You end up trying to say, I don't even know what this says anymore.
Amendment 7 amends Amendment 5, which amends Amendment 4, and somebody mentioned an Amendment 11, but we can't find it.
All
Let's
right.
restate the trust.
All right. So true or false? A trust is the way to go in avoiding all the things we've talked about so far. True?
True.
Right? Okay. All right. So Ray, you mentioned earlier, I think it was you, maybe it was Steve, one of you, but about forgetting to fund the trust. So can you talk about that and how that specifically relates to, say, a piece of real estate?
Yeah, so your trust is your instruction manual. It's your instruction manual for life and death and even after. So part of that instructions, though, you can have instructions that say, let's pick a house. I want my house to go to my 2 kids split evenly and whatever you want to. But if that house is not owned by your trust, then the instructions in your trust don't matter. Because that house, it needs to be actually owned by your trust for the instructions to attach. We call that funding. It's a weird term, I don't like it. What it means is attaching all of your assets to your estate plan properly. And so sometimes in each asset it's confusing because each asset is tied in a different way. So banks can be owned by your trust, homes can be owned by your trust, IRAs cannot because that's a taxable problem, so we want to make sure that those are beneficiary to your trust the right way. And so every single asset you have has to get into your trust. The way we talk about it a lot of times is your trust is your treasure chest. It's your treasure chest that you're going to put your treasure into. If you show up on the beach and there's a treasure chest and you open it up and there's nothing in it, now you just got a big heavy box, and that's no fun. So you want to make sure your treasure is actually put into your treasure chest to make it a treasure chest. And then on the side, you've got all your instructions on what to do with it.
Okay.
Yeah, I think that's exactly right. I think that, you know, as far as the actual home, you know, one of the processes when we're meeting with our clients and we go through the funding process is you just kind of have to explain to the client how each item gets transferred, because they each have generally a different way to make things more difficult, I guess. And so a home is usually going to be a deed, you know. So most attorneys, I can't speak for all of them, but I think probably both of us, we're going to do the deeds that transfer the home into the trust. We can make sure the real property gets in the trust. Where it becomes less in our control is all the financial assets. And so we have to help and guide and sometimes cajole clients to fund their trust with the assets that are financial assets and things of that nature.
So I've certainly come across clients with homes that, you know, people have a trust, but the home isn't in there. So I'm not sure how that happens, but if they paid somebody to set up their trust, but are you saying that?
Not all attorneys do it. Some attorneys will say, here's your trust, better go put stuff in it, good luck. That's it.
Okay.
So I would consider that a very transactional practice. I don't think that's what either one of us run. We are much more, you know, it's not at the end of our relationship is when I hand you those documents. But some of the attorneys, you gotta remember, every attorney does trust, okay? Even a lot of the personal injury guys, because it's an easy way to keep the lights on until they get what they really want, which is a good personal injury case. So, you know, are you going to get the same trust that you would get from us? I would gather not, okay? And you're also not going to get the same service. But that would be exactly where I would expect that you might not get it from. You might get, here's your trust, because that's what you asked me for. I gave you a trust.
So, I mean, maybe some, you know, you have an attorney that you've used in the past, and they're not expert, they're not an elder law attorney.
Right.
So most of those, would you say?
A lot of them just have one trust that they copy and change the names on over and over.
Okay.
Yeah. So rip the front page off with your name on it, and rip the back page off with your signature, and I don't know whose trust that is anymore.
Would you say that 401ks or IRAs are not in a trust?
He did, but I agree with him.
Well, sorry. Is that because you already have beneficiaries listed on those?
No, it's because an individual retirement account and 401ks have tax qualifications to them,
Oh.
and to hold those tax qualifications, you have to hold them in your individual name while you're alive.
Oh.
Yeah.
But you are correct. The way you then avoid the probate issue is the beneficiary designation on it. So one of the things that we talked about in our prep for this is that one of the misses for people is that their estate plan is not limited to their legal documents. You also have to look at your beneficiary designations on your IRAs, your 401ks, your retirement plans, because those control those assets. I can write whatever I want in that trust about your retirement plan, but if it's not going to get into the trust, it has no bearing on it whatsoever. So that beneficiary designation is very important when it comes to those retirement plans.
So in other words, when we took out our IRA, we put our daughters' names on beneficiaries. That's all that needed there.
I would revisit it if I was revisiting the estate plan personally. That's the way we do it, but it probably would be okay. Normally, you would name each other first, though, for tax purposes, and then you would name your.
We go at the same time.
Actually, don't do that. It gets really confusing.
Should never be together.
Yeah.
You said, and then you would name.
Generally, whoever else you want to get it afterwards.
Okay.
So there's like a
Name
primary
your trust
beneficiary.
as the-
You can. I mean,
What's
different
the
attorneys have different opinions on that. We, in a situation where we don't have other reasons to name the trust, we usually will name the individual or suggest the client name the individual children. We did have a case where we had a daughter who had some significant issues with gambling and spendthrift issues. And so we pushed the IRA because it was a significant asset through the trust, because then we can prevent the daughter from making bad decisions with trust language, okay? But if we didn't have that, more often than not, we, in conjunction with your financial advisor, who also is involved in that decision making, would tell you to name the children.
And we go the other way. Because,
You,
yeah, because our trusts are built for protection purposes when you're gone, and we like to have that IRA protected after you're gone. But the one thing to know is you have to be very specific if you're going to ever put qualified retirement account money into a trust. You have to know that trust can do it. And that's the problem with a lot of generic trusts out there is, can your trust actually handle what you're funding into it? And if you haven't sat down with your attorney and really had that conversation with them, you could mess something up by putting the wrong thing into that trust, or putting it in there the wrong way, or something of that nature. So that's why it can't be the general practice, here's your trust, have a nice day. You really need to know what you're doing.
So, just to backtrack here, kind of confuse my little brain. Are you saying you guys do things differently
Yep.
on that?
Based on our clients' goals, yeah. Because I
Okay.
think we have, our client base has just slightly different goals a lot of times.
Okay,
So it's all based on the goals.
Yep.
it's based on the plan.
So
Yeah,
one of the
based on the
things,
plan.
like, say you had a client who came in and they were concerned that they had a child who had significant potential creditor issues and things like that down the road, okay? What happens is your IRA is a spendthrift when you own it. But the court has decided that when you leave it to your kids, you do not get creditor protection. Their creditors can invade it. So in a case like that, we would push that IRA through our trust, okay? And you want to have, they call it conduit language, or the different type of language that is making that trust specifically designed to receive that IRA. And what we don't want to do, and this is why it's so important, is if you don't have the right language, it becomes a taxable event. And that is the worst thing that somebody could do to you. So when we talk about that personal injury guy who copies that same trust and then you inadvertently didn't know better and put your IRA through a trust that's not set up to handle it, you just triggered taxation on whatever that IRA was.
Holy cow. Well, that's worse than probate.
Oh, way worse.
if
Yeah.
you have the trust is set up to fundle into children's individual trust, that is when you would put
You would
the,
generally want your IRA to go through your trust then.
okay.
Because you want to use the benefit of those trusts, okay, is only attained for assets going through your trust. So if you pass, because we see it sometimes where people will have those sub-trusts for their kids, and then they've got life insurance over here, they've got beneficiary designations over here, they've got all this stuff outside the trust. If you don't push that through the trust, you may not put anything in those sub-trusts. So you have to push everything through the trust to get the advantage of that trust power.
Okay, so life insurance should be, the beneficiary should be the.
Or the owner, depending on the
the
situation.
trust.
Yeah, I mean, it could be either one.
So, all great questions, but if you wouldn't mind holding your questions till the end, so we can.
I'm so excited somebody wants to ask me something.
Sorry. We're gonna give a good 30 minutes. Doesn't it make you feel really smart?
Well, you know, nobody else wants to talk. You go to a cocktail party,
Yeah,
nobody wants to talk about a trust.
I would, so, all right, so we did our true or false, all right, we talked about pour over wills, let's see, all right, so we were talking about funding the trust. Did we pretty much cover that? Is there anything else?
So,
I think so.
So,
It's very specific.
and I do have, so in selling real estate, okay, I always ask people, how do they want to take title to the home? Because some people do have the trusts already. And I think, correct me if I'm wrong, if we title it that way when they purchase it, that's what puts it,
That's
plugs
funding,
it into
right.
the trust.
Yep.
Okay, so I actually get some pushback on that from
From people?
clients. And they say, oh, don't worry about it, we'll do that later.
No, they won't.
And I try to say, well, it's just gonna cost you more money if you do it later.
We're gonna do filing fee.
And what if you forget?
Exactly.
That's what I,
Okay,
It costs a
so,
lot of money.
okay, all right, so I'm doing right then.
Right.
Okay, thank you.
if you have a trust and you're not naming your trust as owner of your property, why do you have a trust? That's always my question. The people are like, well, I'm not putting my house in my trust. Well, why do you have your trust in? If it's not going to control one of your largest investments.
Yeah, when you look at people's asset makeup, the majority of clients come in with qualified money, IRAs, 401ks, which can't go in the trust, and homes.
Yep.
The rest of their assets usually are smaller in comparison. So if you're not gonna put your home in, what do you want to trust for? Because your home's going through probate then too.
And we all know everybody's home values it.
So, one
Okay.
question, sorry.
Cheated, I would like to ask.
Sorry, I'm the bad guy here. So just make note of it and we'll be there in a
We'll
few
be here.
minutes here. So you were talking about children, you mentioned several times. So what if I don't have children? Do I need an estate plan?
If you want to guide where your stuff goes, you do. I mean, even if you want it to go to charity, you need to say who gets it. If you don't, if you put nothing down, there's good news. The state wrote your will for you. It's called intestate succession. And the government's going to decide where your assets go. And so there's this whole table of things, and it'll probably go to nieces, nephews, who knows. There's actually an article probably a couple years ago about 3 Armenian widows over in Granite City. And they had passed away. They'd been saving their money diligently, lived in the same little house, and they had like $4 million. Didn't have any planning in place whatsoever. And there was this huge court battle going on with people from Armenia filing motions and all this. And you know what they were doing? They were spending all that money because they didn't know who was supposed to get it. They didn't know who her relatives were. But in most cases, they're going to go down that table and they're going to find, oh, well, you know, they didn't have kids, but they had a sister, and their sister had kids, and so that's our closest relative, so they get the money. But what if you didn't like those kids? You know, I personally, maybe I'm wrong, but I want to control where my stuff goes. I want it to go to somebody I liked, somebody I cared about, or a cause I cared about. So I don't want the government doing anything for me, in my world.
Well, and I also think of the circumstances where, things get divided up, and with a trust, you have control over it. Sometimes there are people that that it would ruin their lives if they get the money, if it's not being monitored by somebody or released on increments. And are those all the kind of things that you can mandate in the trust?
Yeah, that's all part of that design discussion we were
Okay.
talking about.
Okay.
So like, I think I told you all on the phone, I have 2 sisters. One of my sisters and I do, okay, we're gonna make it. The other sister lived in my mom and dad's basement because she doesn't make good decisions, and her husband has chosen to pursue a life of playing games online rather than working. So.
Cousin
if we-
Eddie.
Huh?
Cousin Eddie.
Right. So she doesn't get anything outright at my parents' passing. It all goes into trust because they will spend it before it clears the bank. That's the way they are. I mean, they're payday loan people. They're running down there and their next paycheck is gone before they even have, earned it. So that's where you're protecting people from themselves. It was exactly what I was talking about with that daughter who has the gambling issue. She was entitled to potentially almost $1 million in IRA. You know what she'd have done? She'd have cashed it in, not paid a dime of taxes other than what they withheld, went and gambled it away, and then the IRS would be chasing her down saying, you owe us money. And you do not want the IRS chasing you.
Okay, let's see. So yes, we should have an estate plan even if we don't have children.
I believe
Unless
so.
you don't,
Unless you don't care.
And that also begs the question. Remember, your estate plan is not just about where your stuff goes when you die. It's also about who's going to take care of you while you're disabled. So the disability planning is a very important part of your estate plan. So much so that if you don't plan for your disability, you can end up in probate court while you're alive. Because that's what we have to go to get a guardian or a conservator appointed, somebody to be able to take control of you and your assets if you're disabled and unable to manage your own affairs. So a lot of estate planning is taking care of you. So if you have zero, I have nothing at all to my name, I have no property at all, You still need an estate plan because who's gonna make the medical decisions for you? You still have you. You personally are part of your estate, so an estate plan has to be done no matter what.
Wow.
That was gonna be my question, and if we're on joint accounts and something happens to me or her, and we wind up in assisted living and can't handle it ourselves, and then die, how does the assets, how are they taken care of to where the nursing home doesn't get all the money?
You gotta plan ahead. Get your estate plan in place and get the plan. That's the problem, is you have to plan ahead. It's very hard to do that plan at the time you're going into the nursing home or at the time that you're becoming disabled. So planning ahead, planning while you're alive and well is the most important part of that, to know what's going to happen, to know who's going to be in charge, to know what those steps are ahead of time before anything happens. And covering all the what ifs. So a lot of times we see it on, I see estate plans for, it's best case scenario. Well, I'm going to die, and then my wife's going to die, and then my kids are going to die, so we're going to plan this way. That's not necessarily how life's going to work. We've got to go through step by step and make sure that we cover all the what ifs.
And I think if you go back to what we both kind of intimated in the very beginning, that first meeting, when you're sitting there and you're talking to your attorney, you would want to express that concern. What happens if I pass away, or if one of us gets sick and one of us goes to the nursing home? How is this plan that you're doing for me going to help me? Okay? And if the answer is, oh, I'm sorry, that doesn't help you, then you better go find somebody who does the type of planning that will. Not necessarily saying you have to come to us, okay? But there are other people who do this, and it can be done, especially if you're doing it in advance. Our expectation, I assume yours is as well, that for a married couple, we don't anticipate losing a whole lot of money. We expect to protect the lion's share of it for that healthy spouse.
And correct me if I'm wrong, there is, even when you plan for the situation you talked about, there's a look back period.
Not between married couples. There
Not
is if you
between
start giving to kids or other people outside of the marital couple.
Okay. But so yeah, if something happens.
So I'll give you a perfect example.
Yeah.
I've got an uncle who called me about 7 years ago. He has 2,000 acres of farm ground in southern Illinois. Okay, I don't know what it's worth, but it's worth a whole lot of money. He had been driving a cattle truck. He also has a cattle truck system and cattle. And so he had some problems. He went to the doctor. He has basically diagnosed with Parkinson's. So if you know anything about farmers, they care about one thing: ground. He did not want to lose 1 acre of ground. So there is a trust. It's an irrevocable trust that we placed his farm operations in. And now that is a 5-year look-back issue. So if he had to go to the nursing home the next day, we would have had to tell the Medicaid agency, oh yeah, yesterday we transferred this farm. Okay? But he didn't. And it's been 5 years. And so if he goes there tomorrow and they say, well, Mr. Foreman, do you have a farm? No. Do you have a cattle trucking business? No. Do you have hundreds of heads of cattle? No. None of it's countable. They won't touch it. Okay? And so what you're really doing, and what he and I are doing when we're doing this with the family, is the moment we put that plan in place, we knew exactly what was going to happen for my uncle if he made it 5 years, but we also knew what was going to happen if he didn't make it 10 minutes. We had the other side of it planned. Because the worst thing people do is they get told, give everything away. Okay? That doesn't work, folks. That will cause you major problems. But you can give stuff away. You can give lots of stuff away. You just build in a plan to deal with the look back and penalty period. And that's where the language in your documents allows you to do it. So if my uncle had done those documents and then years later he couldn't sign anymore, his documents, if he came to one of us, would let his kids do it for him, would let his kids take those actions. That's why you have that initial session and say, what's important to you? For my uncle, saving farm ground would have been a critical step for him. So we know what we need to put in his documents.
So brings up the question, okay, when should we be looking to do this as far as like age goes, time of life?
On your 18th birthday? Yeah, you think of it, so if you've got grandkids, children, things that, this is something to let them know. When you turn 18, nobody has rights to you but you. So nobody can go to the hospital and decide what to do for you. Nobody can go to your bank account and help you out. Technically, your spouse, if they're not on the account, isn't supposed to either. Most banks let you slide with that type of stuff. But technically, your spouse can't make medical decisions for you without the proper paperwork. Without your estate plan, you could be in a world of hurt where there's nobody there to take care of you. And we saw it with when I say 18, because we saw it with one of our clients. She called us and like, she had set up the surgery, so her daughter was going to have knee surgery from a softball accident. She set up the surgery, went to the pre-surgery appointment, set everything up with the doctors, was at the doctor's appointment, set everything. Called up the hospital and said, okay, we're having surgery in two weeks. I know my daughter's not going to pay attention, so can you send me the post-op information? And they said, yeah, no problem. Oh, wait, when was your daughter's birthday? Oh yeah, she had a birthday last week. Yeah, I'm sorry, she's 18, we can't talk to you anymore. You need to get some documentation before we can talk to you about anything.
Or a car accident if your child's in one?
Well, and yeah,
Or at college?
your daughter's at college and friends said they're at the hospital and we don't know what hospital, and we can't call the hospitals because they won't tell us. That's happened before.
That actually just happened a few years back at the Lake of the Ozarks.
Yeah.
There was a boating accident, and a bunch of kids had gone down from St. Louis that were varying ages of under and over 18, and there were parents trying to call around and figure out if their child was in a hospital from that boating accident, and they couldn't get information.
Right.
So it's very real. I've got a 18-year-old son who's going to leave in August and go play hockey for the Weyburn Red Wings up in Canada. Getting his powers of attorney in place is critical, because obviously if they call us and they need some kind of guidance, we have to have that, because just because I'm an attorney doesn't mean I have any special magic that they're going to listen to me any more than if I didn't have them in place.
All right. Well, I have my youngest sitting in back there, Claire, 22, so we need to
Give you
get
power of attorney.
this set up.
Yeah.
Stuff set up.
All right. So let's talk about updating the trust. How often should we update it, and what are some of the big reasons why we would need to update our trust?
So we say updating your trust, taking a look at it at least, and updating it, looking at it at least every 2 to 3 years, to be honest, because we talk about the 3 L's of changes. Life, so life changes, you change, your ideas change, things like that. Your assets change. Maybe you bought a new car, maybe you switched banks, maybe you switched products with your financial advisor, new insurance, all sorts of stuff. So life changes quite regularly, and you need to have your estate plan kept up with that. The laws change quite regularly, and you need to make sure that your estate plan keeps up with the laws, to make sure the tax laws and things like that are staying up. And then learning is kind of the big one in our world. It's all the learning that we do as attorneys, learning new ways to plan, new ways to make the language, new ways to do that. Why should your plan not be as good as the plan we just did yesterday? You know, you should be kept up to date. And then you also learn. You learn more about how you want your assets to be, what your values you want to leave behind, and things like that. So it's very important to take a look at least at your plan with an expert every 2 to 3 years to know that it's at least, maybe it's okay, but maybe it's not. And again, if you miss that update, that's going to be a much bigger problem than taking the time to sit down with somebody and see if there's an update that needs to be made.
Yeah, I think that's exactly right. The only, I think, and it can flow right into what he's telling you, the only thing I think you want to make sure you think about is, as time goes by, your goals and needs change, okay? So if I'm a 35-year-old individual with 2 young children, I need an estate plan because probably my biggest concern is taking care of those kids if something happens to me, okay? Now, if I get to be 55, 65, now I'm probably more worried about probate avoidance and capacity planning. And as I get older, 65-ish, now I might be starting to say, okay, what about long-term care? And so each of those types of planning would be slightly different, okay? If I'm 35, I don't need a bunch of long-term care planning language in my documents, okay? That's really not what I want in there. But if I'm 65 and I have any caring about my spouse, I probably want long-term care language in there.
So let's talk about general cost. So can you speak to generally how much it costs to have a trust set up?
It depends. Which is, so we have JD degrees, right? So when you come out of law school, you get a JD. It just depends. It depends on what your goals are, and that's the issue. And it depends on what you're getting for that too. So the cost should be tied to your goals and what you're actually getting out of that. So are you just getting paper, or are you getting your documents put in place and your goals accomplished? Are you just getting paper with some instructions to fund it, or is somebody going to help you fund it? Is there a way to help you maintain it? Things of that nature. We see a lot of very cheap paper that's out there that it's actually pretty expensive paper because all you're getting is the paper. So the price, the fee range is quite broad across the marketplace. And so you just need to make sure that what you're getting is what you're paying. And it's very simple. You get what you pay for a lot of times. And like I tell people, I can sell you a cheaper car, I just can't put tires on. So sometimes you're going to have to make that investment. But look also at the investment as percentage against the estate that you're saving. So we do a lot of that. If you think about how much you spend on house insurance and how much you spend on car insurance for something that's never going to happen, hopefully, this is kind of insurance and work for something we know will happen. Death is, yeah, we still have 100% of our clients are still eventually going to die. We haven't been able to fix that yet. So it's an investment in that. So the fees, the range is so high that it really depends on where you go and who you talk to.
All right, so I'm gonna let you answer as well,
Uh-huh.
but I'm gonna press you guys a little bit for giving us some kind of range here, because this
Okay,
is
I'll give you a
sounding
range.
Yeah, I can give you a range,
astronomically
right.
expensive.
So, two things I would say about it. He's 100% correct. You would never go to your doctor and say, I'm sick, how much is it going to cost to fix me? Would you? Okay, if you would, I think you'll get a new doctor. It's the same thing when you come to us. If you say, how much is it going to cost for my planning? Well, you haven't told me what you want to plan yet, right? You haven't told me what you have. You haven't told me anything. So in our practice, and I'm going to give you ranges, okay, so I'm not trying to hold out on you. In our practice, our first meeting is what we call that vision meeting. At the end of it, once I know your situation, I'll tell you exactly what it's going to cost. At that point, you can tell me, no way I'd pay you that. I didn't even like you that much. Okay? And you're free to go. You don't owe me a thing. And I probably, you do something similar. I'm not trying to say we're exclusive.
Exactly the same.
Are you saying it's complimentary?
Ours is.
Yeah,
If you come to a workshop like this, or our workshops when we do them alone, that's actually what our card is. It's called a vision card. You can come in, meet with us, and we'll go through your specific situation with your facts, your goals. I'll tell you what I think, as with Raymond, okay? And at the end of it, if you say, hey, I'm interested in that, what would it cost? Then I'm going to tell you, okay? Now, what do I normally see in the range in that? Anywhere from $1,500 to $5,000 is probably a typical range, okay? If somebody's on the very low end of very basic planning, they get down that. Now, we don't do, so in our firm, we don't do standalone powers of attorney. So if you call me up and say, hey, I just want a financial power of attorney, that's not us, okay? We're doing planning for families, okay? We're doing planning for individuals. So we don't have anything down at that extreme low end. But that's kind of the ballpark. Now, I'm not going to tell you there aren't people who pay a lot more than that. There are. But that would be the general range that we would expect from most people coming in to plan in kind of that pre-planning, you know, I want to get my estate in order range.
And for the plan itself, for the trust and documents in the estate plan, our range is exactly the same. It's $1,500, $5,000. But again, but there's other stuff that goes into that too.
I was seeing some big dollar signs there, so that sounds really.
Yeah.
I always hate it when I finish a meeting and I say, it'll be this much, and they say, oh, I thought it'd be so much more. I'm like,
Yeah, sure. I didn't think pay more.
but fortunately, our fees are set, so it's
Yeah.
the same. I mean, we don't really vary.
But here is one of the red flags. And we see it, we get all. What's it going to cost for my estate plan on the phone? Right. I don't know you. If somebody can quote you your estate plan without talking to you and knowing what your estate plan is going to be, they're just giving you the same estate plan they just gave the last person. So watch yourself.
But if you've got a plan in effect already, and all you have to do is make modifications to it, it wouldn't be as high.
So we wouldn't do that, okay? So if you came into my office and we go through your plan and all I think you do is need an amendment, I'm going to tell you should probably go and talk to your existing attorney, okay? And you want this amendment. That's not our practice. If you come in and your plan is not right for what you're trying to do at all, then I'm going to tell you what it would cost, and if you want me to do it, fantastic, and if you don't, you're free to go. But for us, doing the little amendments like that wouldn't make any sense for us. Our firm is very, very hand-holding, very much interactive with our clients. There's a lot of contact, and so a standalone amendment makes no sense for the way we do things.
Yeah, same way. We do it the same way.
So I have a question that I want to ask. What happens when your attorney passes?
Well, that would be me. So,
Or Ray?
yeah, so, and we talked about this, all of us have partners, okay, so we're not the only person in either of our firms.
Right.
So there are other attorneys that work in our firms that would be the backup to that. Everybody builds into their system redundancies, so there's something happened to both of us, and we're on the same plane where the two married people were on, and we all went down in a big ball. Then there are other attorneys that will take over that caseload and deal with it. And in worst case scenario, your documents will work with anyone, okay? You just need to find somebody else who does estate planning and elder law so they can tell you how to use them. You wouldn't want to go to that same personal injury guy that does basic trust because he won't know what he's reading, or she wouldn't, but any elder law estate planning guy should be able to tell you how to use it.
I just had a
I'm not allowed to answer your
I
question.
know, I just want, you were talking, and I was thinking about my clients. I'm with Partner Ritter Senior Services, so our clients, their income might be a little lower than you guys. So do you do like pro bono work or anything? Because some of our clients, they only got that one check that they get once a month.
I mean, we do occasionally pro bono work. I mean, my partners refer to it as, you know, that I get that moment where I just like the family and decide, yeah, I'm going to cut you a deal.
Because it's just basically seniors we deal with. They
Right.
stay by themselves.
Yeah, there are organizations specifically designed for that. That we,
Yeah, well, we
Let
looked
people
at
do it.
some,
Yeah.
but we haven't been able to find any just yet. We haven't found any.
and, yeah, so there are some out there. We can talk.
So yeah,
Okay.
maybe after
Okay, yes.
this, you guys
Yeah,
can
yeah,
talk,
yeah.
and
Yes,
yeah, I
ma'am.
mean, we'd love to help you with that.
Okay, thank
Yeah,
you.
okay.
And then going back to what happens to your attorney, remember, it's your documents, but well, like Stephen said, you need to make sure that the next person in line knows those documents too. And so making sure that your attorney, their backup is not, you know, well, it's my traffic law friend over there who's gonna come in and take care of all my files for me.
Yeah.
You need to make sure it's actually an estate planner who's gonna step into that role for you
So I
as
think
well.
that would be a really good question to ask somebody who you're looking to hire to do an estate plan for you, is what is their succession plan?
I think also looking at the firm, I think if you came into one of these two firms, you're going to find out that if you have a divorce case, we don't do that. If you have a personal injury case, we don't do that. You have a traffic case? Nope, not me. I don't even get my own tickets fixed. I send them to my buddy. Okay, so from that standpoint, all we do is estate planning and elder law. So anybody who's behind me or partnered with me is doing the same thing. We did not, as a practice, decide to expand, and we won't. So from that standpoint, when you look at that firm, if you go in to meet with somebody and it's really just a building that has 5 separate attorneys in it, one does estate planning, the other one does divorce, the other one does bankruptcy, then you really don't have a backup plan because those guys don't know how to do the type of planning you're talking about.
So, question that I was thinking of also, what happens if you're very private and you don't share, you have this trust set up, you've gone and paid all this money, but you don't let maybe your trustee know that it's set up and who to contact in the event of your death or disability? How does that, how does that handle?
The analogy we use is if you want somebody to be there at the event, but you don't want to tell them any of the instructions or how to get there, or when the date is, or what's going on before that, they're probably not going to get there very well. And they're not going to know what to do when they get there. Estate planning should be a family project. But you don't have to give all the information. So when we do family meetings with our families and sit down with their kids, with their trustees, with their beneficiaries and say, here's how the estate plan is going to work. I start the meetings, I like to throw jokes in once in a while. Start the meeting with, you're going to get absolutely nothing because mom and dad are going to spend every last dime on their way out, bounce their last check, and that's it. If you get anything between 0 and $10 million, this is how it's going to work. So we don't even talk numbers, we don't talk about what it is, how you own, what you own, because one thing, it's not very useful because 10 years, 15 years from now, you're not going to own the same thing. It's going to be different numbers, so why are we talking numbers now anyways? But talking about, here's who to call, here's who's in charge, here's how it works, here's the documents you need for this, here's the documents you need for that, here's the instructions, here's where to turn, things of that nature, is very important to to have people know ahead of time what it looks like, and also to kind of sniff out problems. So you can sometimes go, okay, well, we named Susie the trustee. Fred, are you okay with that? And most of the time, our clients will come to us and say, Fred's not going to like that. He's the oldest. He should have been in charge, but he's just not that good at it. Okay, we go to the meeting. Hey, Susie's in charge, Fred. We wanted to make sure you were okay. He's like, yeah, she's so much better at that. That was a good choice because I'm no good at any of this. And there's hidden stuff like that. But having that ahead of time, knowing that, okay, it's going to be okay. We have everything in place. Everybody knows is very important. So don't be private with your estate plan if you can.
What if you don't have anybody? What if you don't have anybody you can name?
Part of that is helping you through finding someone. Part of good estate planning is finding someone for you.
So we're getting short on time here, so I'm gonna ask real quick some questions if we can.
Rapid fire.
All right, so anyone heard of a deed upon death? Okay,
Same
no.
thing as a POD.
Or TOD. Okay, and is that a good estate planning tool?
I assume you mean beneficiary deed is what you're really probably saying there.
Okay.
It is a very basic probate avoidance device. You can use it in lieu of like a trust to avoid probate. Would we use it? No, we never use it. There's a lot of reasons it's not good for what our clients are trying to do. The biggest one is that the state can still file a lien against it. So we don't do it for that reason.
Okay. How about a quitclaim deed? Is a quitclaim deed a good estate planning tool? True or false? False.
False. It's a tool. But it's not a quit claims we don't like. Period. We like to actually warranty that we're transferring title. All a quit claim deed does is transfer title to someone or something else. It is not a plan. It is not a way to avoid any of the things we've talked about necessarily. It is simply a transfer of that property.
So it doesn't check everything.
Yeah, it doesn't cover anything other than giving your property away.
Well, and it also then is subject to the 5-year look back.
Yeah,
the
so
penalty
we're
period
gonna
rules.
rules
And if you're talking about taxes, you get transfer basis. So if the property is highly appreciated, you're going to get the privilege of paying capital gains tax on it when you sell it down the road.
You guys have mentioned taxes several times now, so.
Everybody loves taxes.
Yes.
I'm guessing that you have to really stay up on that and work closely with people's
CPAs.
financial advisors and CPAs?
Yep.
I think you have, as an attorney, if you're going to do what we do, you have to be at least conversant in the tax law. I don't file tax returns personally. I have somebody
What?
to do mine.
You don't file them?
I don't prepare them, I guess is a better way to say it. But, yeah.
Wait a second.
Say that
IRS calling me.
It's on tape. Here.
But I think that, you have to, in our world, we kind of look at things and say, long-term care costs is probably one of the biggest risks you have. On the heels of that, what's the next one? It's probably taxes. It's probably capital gains and income taxes on what we call IRD assets, income respected deceit, which is 401ks, IRAs, those types of things. So I think all three of those should be part of your plan. Because it doesn't matter what branch of the government takes your money. Nobody wants the government taking their money.
Are there any situations where I don't need a trust or a will?
When you ask that question, I hate to answer that and say yes, because I'm going to get a call from one of you all's kids just chewing me out like you wouldn't believe if I say yes, there's a situation. I think there are instances where somebody had really modest assets and maybe didn't have a home, something like that. You could try to use pay on deaths, transfer on deaths. I agree with what Raymond said. You better still have those powers of attorney in place. But for transfer purposes upon your passing, you could probably self-help your way through it if you have a limited asset base. If you have more assets, you're actually making a poor decision, if you ask me.
And when you get down to it, when you talk about all these things, we're talking about tools. So the deed is a tool, the trust is a tool. All the documents themselves are simply your tools. What tool do you need? We don't know until we know what we're building. So we need to know what we're going to build there. So are there some instances where you don't need a hammer? Yes, maybe. But for the most part, that hammer is a pretty useful tool. So all the documents what we say is look at your estate plan in a whole. So do I need a will, do I need a trust, do I need a power of attorney? You need an estate plan. And that estate plan needs to be full of the right tools at the right time.
Okay, thank you. Well, I hope today's seminar has been beneficial. So our goal with these monthly educational seminars is to bring you more services to help you live the best life that you possibly can. And I mean, I thought this was great. Thank you so much. Can we get a round of applause So they're going to be sticking around to, if you have very, very specific questions, but we have about 15 minutes left that we will try. If you want to raise your hand with a question, let them answer as many as we can and the time allows.
You talk about the bank. What if the bank is the one that changes their name? Is that something you have to, my bank has changed their names 4 times.
Yeah.
Watch it and double check. So anytime there's a
Same
change,
name, but
yeah, anytime there's a change, double check. So it's always worth a double check. If it's already in the trust titled one way, it should stay that way. I've seen beneficiaries disappear though, from life insurance companies that changed and the beneficiary designation disappeared. So always double check whenever something like that happens.
That you still have the same names on your
That everything's still
accounts.
right, that the account name is correct and the beneficiaries are correct, depending on how you plan it.
But hear what he's saying. So if you have a life insurance policy and they change,
Yes.
the exchange of documents doesn't always go seamlessly. So all of a sudden, you may have a life insurance policy and the new company has no record of any beneficiaries. And if you passed away, that's a problem. So that's where he's saying, if you have an instance where you go through that, you want to back that up. You want to check on that.
Okay.
April?
So what if, for example, I mean, a person who possibly have dementia or whatever, can remember if I actually have the past stock of retirement? What do you do about that?
That's hard.
Repeat the question.
Yeah.
So the question is, what if somebody has dementia or debilitation where they don't necessarily remember what their financials are, if I heard it correctly? That's really hard. It's doing a scavenger hunt. It's digging through all of their documentation, digging through everything we possibly can. It's just hard.
Yeah, I actually had a phone call this morning with a client, and we're getting ready to do a Medicaid app for them, and they keep finding more assets, which is never a good thing to have. Well, not a bad thing.
This is good bad.
Yeah, it's a situation, kind of a catch-22. But what I told them, and what we generally recommend doing, and what we try to do for the client is, one of the areas that you can find stuff is look at your tax documents. If you're getting 1099s and you haven't shown me a statement for Prudential, you probably have a Prudential asset you haven't told me about, okay? So we ask for tax returns even though we don't have to send them to Missouri, and that's what we're trying to do is locate assets that are missing. Now, what that won't find is the timeshare that doesn't produce any income that's worth some amount of money, because there's no way that you're going to see that on a document. So it really is, you just got to scour through the information, and you know, there's cases where, you know, that the family hasn't been able to really communicate with that person and get that information, and there's no way around it. You got to dig through the information. That's me.
I want to revisit the statement you made about your uncle and the farm, and that you created a irrevocable trust. So, who was the trustee?
In his particular case, it's his son, who's a prison guard and a farmer with him.
Okay.
Generally, when you're creating an irrevocable trust designed to protect your assets from long-term care, you're going to name, what I tell people is whoever you trust, okay? A lot of times that's your kids. I've also had families where that isn't our kids, okay? And so it could be your neighbor, it could be your pastor, it could be your bunco buddy, it's whoever you trust. Because the whole idea behind it is we want to put it there, but we want to put it there with someone that if you need to deal with it, you can kind of still guide them. We don't want to lose total control, just direct control.
Right. So we could put Chief Stephen Jones' name down on it.
You could not. We actually do not serve as trustees ever. I think that's really
Kind of a
great
conflict,
line.
huh?
We've had a revocable trust for over 20 years now. My husband just passed away. Where am I?
Depends on the trust, depends on the estate. So one thing, we talked about avoiding probate. Probate is one system of settling an estate. Every estate, whenever someone passes away, really should be settled in some way. There's steps to take and things that need to be done. What those steps are and what needs to be done is different for every estate depending on how it's planned out. And sometimes it's very simple. We just do the documentation and take names off accounts and put them in the right names. Sometimes it's going through the trust and settling the trust right and doing things of that nature. The thing, even the best estate plan in the world does not have hands and legs and can't go sign things and do stuff itself. It needs to be executed and settled.
Now, like, our daughter is power of attorney and is, to take charge.
Mhm.
So can she kind of step in now, or was?
Do I step in at this point or not until my mother passes? If both names are on there, the trust is for.
So there's two different documents you're talking about.
No.
Trust and power of attorney.
No, I have a trust.
Right.
But everything, she was more or less.
I'm the executor of the power of attorney, is what she's
So the trust is going to have language in it of who the trustees are, okay? I'm going to guess, I don't know if this is right, it was probably the two of you.
Mhm.
With his passing, it's probably now you. So the items that are in the trust, right now you're in charge of, your daughter is not. The items that are outside of the trust, if your daughter is your power of attorney, technically your agent, okay, depending on how that power of attorney is written, it could be immediately effective, or it could be springing in some cases, depending on how it was written. It could say that you have to become, where a doctor says you can't handle your affairs before she has authority. But that would only cover what's outside of the trust. So if you remember that column that I was talking about, the stuff that's in your trust, the trustee controls. The stuff that's outside of your trust, you can still control it because you're the owner, but if you have an immediate power of attorney and she's your power of attorney, then she can also be involved in it as well. But you have to understand how your assets are allocated in that plan.
So is that something that when you have, in your situation, they should be contacting the attorney that drafted up the trust?
We would expect our client to contact us. I mean, that's part and parcel of what we anticipate is like Raymond has said, we're giving you tools, okay? Well, if you don't know how to use the tools, then we need to help you know how to use them. And so to us, that would be exactly when a client might be coming back in to say, okay, here's this book, what do I do with this?
But like, the people who set it up are out of state. So
then you're gonna have to find somebody.
somebody up
So
here.
we find somebody in here locally in Missouri.
Or you could reach out to them and see if they could figure out how to help you with it, but generally speaking, I would argue possibly unauthorized practice of law to start giving you advice on it in Missouri if they're out of state. So I would probably say you need a Missouri attorney, but I would at least call them first and see what they're telling you they're gonna do.
Did you previously live in another state?
Yes.
Okay, so you've relocated to Missouri then. So, sounds like it needs a,
States would
They
make that.
didn't
like-
realize the states.
Yeah.
Yeah.
right, yeah.
I have a quick question. So could you review once again the look-back period? You said the words irrevocable trust. Can you define the difference between irrevocable and revocable? Is, if you have a revocable trust, still appropriate for that look-back 5-year period? And is, my understanding, the way that you described that, putting the assets, so the land, or potentially a house, in the trust's name versus the individual or couple's name and then doing a beneficiary deed, it's better to have, from a look-back asset preservation standpoint, to have it in the trust at all times.
So to answer your question, I would tell you that I always think it's better to have your home in a trust. Now, depending on your goals, it will make that decision as to what type of trust different, okay? If you're trying to get an asset out of your name to protect it, then I'm going to use an irrevocable trust, not a revocable trust. A revocable trust would still be considered a countable asset for purposes of long-term care. And so from that standpoint, the language we put in our revocable trust may allow us to protect assets, but the fact that it's in a revocable trust does not necessarily protect it. okay? If I want to protect something, I put it in an irrevocable trust. I'll give you an example. I got a home down at Lake of the Ozarks on the 18-mile marker. I don't own it. My irrevocable trust owns it, okay? So if I ever get sick like my grandma, I don't have a home in the Lake of the Ozarks. There's nothing to talk about.
So irrevocable means.
I'm getting ready to that.
Okay.
So irrevocable versus revocable. Revocable, the assets are in your name, you can change that trust whenever you want. You wake up the next morning and say, I don't like my beneficiaries, I don't like my trustees anymore, I just change it.
The amendments.
The amendments. Irrevocable, you really can't change it near as easy. Now, I'm not going to tell you you can never change it, because there are ways to still change it, okay? If your attorney knows what he's doing, he can get it changed. But it's going to be a lot more work.
But it's still your asset.
The irrevocable trust technically owns it. So on paper, I don't own that home, okay? Now, if I've picked a trustee that's going to be very malleable to my directions, which is what I would assume I'm picking, then yeah, I still kind of own it. Because if I want to sell it, I'm going to tell my trustee, list it with this realtor for this amount, and when you get an offer, you don't need to think about it, just let me know.
So you would not have both, though? You would not have a revocable trust and an irrevocable trust? So you could have both?
Yeah, because
Some assets could be irrevocable, some assets could be revocable.
so some of my younger clients that are worried about long-term care, they don't want to stuff everything they have into an irrevocable trust because there is a control issue, okay? So they'll start putting some things in their irrevocable trust, but they'll still have a revocable trust where they have other assets that they want to maintain control of, which is what I have. I don't want anybody making decisions over my financial assets right now. I'm not old enough, in my opinion. When I get older, yeah, I'll start putting more and more of that into that irrevocable trust.
So then you feed that trust from the other trust.
From the revocable
basically.
at that time, right.
Does the asset that you put in, though, have the 5-year look back?
When you move an asset to an irrevocable trust, you're saying it's not mine anymore. That starts the 5-year clock, okay? So when I put my home at the Lake of the Ozarks in the irrevocable trust, I was hoping that I was going to make it 5 years and 1 day at least before I would ever need to ask the state for any assistance with long-term care. If I do, that home doesn't count, and it won't count because it's been 5 years, okay? That's what you're hoping. Doesn't always happen, and then we have to deal with it. That's why we said, don't just move stuff, have a plan. Having a plan is what this is about. It is not just, well, if I stuff a bunch of stuff over here, maybe they won't get it. Well, they may not, but it also may go terribly wrong if you don't know how you're going to deal with it if something happens early.
So we need to be doing this before we even think we need it, right?
In the ideal situation, yeah.
I mean, you said 18 years old,
Yeah.
right?
But see, he's saying that at his age, he doesn't want to do it, but yet you should.
No, I'm saying that I don't want to put my financial assets in. I put all my real estate in it. I don't know. If you ask me right now, I'm homeless. Don't have a single home.
So a follow-up question just from a law standpoint. So say, for instance, you're filling out a FAFSA for your child who is going to college.
Right.
So if those things are 5 years past and it's in an irrevocable trust, you don't own it.
So let me make sure we're clear here. There's a different set of rules. The 5-year rule is a Medicaid rule, okay?
State.
State, it was actually federal and state. Every other rule, there is no 5-year rule. So if I move my home into that irrevocable trust today and fill out FAFSA tomorrow, I don't have a home, okay? If I have a car wreck on the way home tonight and it's been less than 5 years when I put my home in there, that home's not an issue. It didn't drive the car. I don't own it. It didn't have anything to do with it. And so from that standpoint, the weird thing about that irrevocable trust is the
trustee
Medicaid
is
rule.
managing it, though.
The trustees manage it, but the trustee doesn't own it. That's a big distinction. You know, people say, well, why don't I just give it to my kids? Because your kids might get divorced. Your kids might get sick. They might have a car wreck. They might have financial problems. That trust doesn't do any of that. The trust doesn't get sick. It doesn't get divorced. So you're safer when you use that irrevocable trust with your property.
If you do that with your kids' names, could they sell your house?
In theory, yes.
One of the big things we see in estate planning is in case something happens to me, I'm going to add my daughter to my bank account. I'm going to add my daughter to my house, and that way, if anything happens to me, she can take care of it, and she's going to get it when I pass away. Also, the flip side, anything happens to her, it starts affecting my property now. So now she gets in a car accident, she gets a divorce, she gets sued, and they're going after everything she owns with her name on it, that includes my house and my bank account, because it was set up that way, versus setting it up in a trust with, setting it up in a proper estate plan the right way. So we see that mistake a lot of times too.
When you have a restatement, do you have to keep all of the old restatements legally?
Depends on your practice. Yeah, you probably should have a,
Paper trail.
so I came from a litigation background when I wasn't court. I don't like being court anymore. That's another reason I do it. One of the things he's thinking about, well, we go to court on the trust. We go, okay, well, the trust says this. We don't think that's what they really meant to do. Okay, well, okay, but they said it here, but they also, that part of the trust was also said here and here and here. And here's 20 years of them restating their trust and amending their trust and changing their trust, and that part was always the same. And the intentions were always the same. And so it does help to have that there as a backup for that reason.
Yeah, I would say that our recommendation to client is exactly around whether or not you're making significant changes. If you're doing the same thing, you're giving everything equal to your kids, and it's pretty much the same, there's probably less of a reason to have that trust. But if you've disinherited a particular child, then you want to keep those for successive iterations, because they may come in and say, well, they didn't understand what they were doing then. That was my sister tricking them. Well, but did your sister trick them back here 5 years ago when they said it, or 7 years ago before that when they said that? So that's exactly when you must, in my opinion, keep it. I don't think it ever hurts to keep it. But, if you didn't, I wouldn't jump up and down and say you're making a colossal mistake necessarily.
So I have a question.
Yeah.
We talked about ranges of cost for setting up an estate plan. And then we talked about all of these things that you have to think about that can be changed and needs to be revisited. So what do you guys, or if you do, if you have a client, how do you make sure that that's being monitored, and I guess, there's cost involved every time they come in? Just real quick, what does that look like?
So the way we do it, we have a client support program. And so what that client support program is a yearly fee to make sure that your estate is staying up to date, so that the way we do it is every year we have a meeting like this, and go over what's going on in the world and what's going on to see if that sparks any change. Every 2 years, we bring you in and update your documents, get new dates on documents, have another discovery opportunity to see if there's any changes that you need to make or anything like that. Once a year, look at all the assets to make sure the assets are still funded in. And then that way, it's the way I say it, it's like the physical therapist for me. If they just send me home and say, go do your exercise, that's not going to work. I'm not going to do it. That's why I have bad knees. What's going to happen is, instead, you're going to come into the office and we're going to get stuff so that you have specific times to make sure you're looking at your estate plan and keeping it up to date, and specific times to check off on assets and specific times to look at it. And then during our program, it's anytime you have questions, anytime you have a change, you need to make stuff like that. It's all included in there too.
So for us, we don't maintain a fee system like that. If you're our client, we'll answer your questions. You come in and meet with us. We tend to meet with clients once a year and go through the same exact kind of process of evaluating where the documents sit or the assets all where they need to be. That isn't any charge. That's all covered for the initial fee with us. And that goes on for pretty much as long as somebody is here. We'll continue with you. Now, if you come in and you hit the lottery and you want to now do a dynasty trust, that's not covered. You're going to pay for that.
Who needs a dynasty trust?
So, I mean, we really just look at this like, what I tell people is basic amendments are covered. So if you say, I want to switch trustee 1 and 3, that's fine. I'm going to hand that to my paralegal, and that'll get done. We're not going to bill you. If you're doing stuff where we're going to have to start rewriting big sections, that's when we would have a cost associated.
Awesome. And so it sounds like it's a lifelong
For us,
relationship.
we believe that, like I said in the beginning, we don't believe this is transactional. We believe this is relational. So when I give someone these tools, now my job, and this is our opinion, is to help them navigate the process and use those tools. Because the average person isn't going to understand how to use them. And I'm not trying to criticize anyone, but it's just, like my dad was a research engineer at Shell. My grandfather owned 2 gas stations. They're gone. I have an entire garage full of red tool chests. It's incredible looking, okay? But if I push the button on my car and it doesn't start, I'm calling the tow truck. I don't have any idea how to fix it. But if somebody came to my house and said, grab that tool and twist right here, I could do that. That's really what we're doing. We're saying, okay, now that this has happened, here's what you want to use these tools to do.
I like estate sales.
I got a quick question. What if the original will cannot be located? The copy of the will is in the trust. Yeah, pour over will.
Mhm.
And the original cannot be located. And there's already been the death, so they can't tell us where it is.
So, do you have anything that needs to go through that will?
There's a house.
Uh-huh.
That
But,
is not
but
in
if
the
it's a
trust.
pour-over will, it's not in the trust?
Right.
Well, I mean, there's a process you can try to go through to get it admitted, but that's gonna be.
Is that probate or?
That's probate, yeah. Hey, you're going to probate, if that's what's going on.
Okay, one more question, and then we're gonna have to.
I have two questions. I have a daughter in New York, who's single. Should we be suggesting to her that she put a trust in place? And secondly, one of you made a statement that to make sure that your trust can handle your financial vehicle or something like that. What does that mean?
Well, when we were talking about that, we were talking about IRAs and beneficiary designations. And so when you're talking about a trust and the language in it, in order for you to name your IRA or your 401k to go to your trust, it has to have very technical and very specific language in it to not trigger taxation, okay? So I think that's probably what we were talking about in that section. I don't know New York law, but I've been told probate fees there are astronomical, like $40,000 minimum. So I would suggest she probably does need a trust if she owns it.
All right. So we want to be respectful of everybody's time. They're going to be hopefully sticking around for a few minutes, and if you do have unanswered questions, just real quick, I want to remind you, if you have an evaluation, please turn it in. We've got a box for you to put it in on the back. Our upcoming seminars, July 19th, The Truth About Living, Dying, and Leaving a Legacy. And then August 16th, it's going to be The Truth About Scams and How to Avoid Them. We're going to have Sergeant Melissa Doss from the St. Peter's Police, and hopefully someone from the Attorney General's Office, Consumer Finance and Protection Bureau. So, thank you, everybody. Was this helpful? Was this good?